What's your thoughts on a home inspector having insurance? Is it good or bad?
You have to have it. It is a mandatory. It is not a question. If you have insurance on your car, you should have your insurance. Remember, bankruptcies are not
You
fun.
sound just like I did the other day.
You have
Saying
to
the
have
same
it.
thing.
But having insurance is the start.
Right.
You have to have an insurance company that specializes in this, who understands the standards of practice.
Yep.
And again, when we get into the agreement itself, we're going to get into this mediations and stuff. And I want to tell one story up front, and then I'll let it go.
All right. Shoot.
As you are a generalist and defer to a specialist, when you get a lawyer, you think that you're getting a lawyer who has background, education, and experience in your profession. Remember, you are as much a professional in the state of California by law as a doctor I would say a lawyer, but lawyers aren't professional. A lawyer, a dentist, a chiropractor, or any of these professions. I once had a mediator. This is a person now that is so experienced, he's brought in to sit as a quasi-judge to help you through your program because he's much smarter. And he kept putting in a standard for a licensed contractor. And this is what it is. This is statute of limitations. This is construction defect, blah, 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 blah. We're down the line. And I turned to him and said, well, what about CREIA? He said, you mean the country that's north?
You mean Korea?
North and west of Japan? That's why in my contracts it says a person with background, education, experience in the standards of practice for CREIA. If they don't have that, you're swimming upstream.
Right.
They have no idea what they're doing. Anyway,
idea.
Go ahead.
Yeah.
Continue, please.
No idea. I mean, it's funny you mentioned the Korea thing because when I do my transcript for my podcast, it always, when I say CREIA, it always puts Korea. So the software's thinking the same way this judge was. By the way, a mediator, is that what you said?
Yes, a mediator.
A mediator is basically a judge who comes in without a courtroom and sits between the two of you, right?
No, it could be, I sit as a mediator all the time, and I have 45 years.
You can just be an attorney.
Right. The key to it is someone who can understand the issues present and try to lead people, not taking a side, but to a point where both sides are very unhappy, but they settle it and close the case.
Right. Got it. Okay. All right. So let's get into this contract. Where would you like to start?
Well, first and foremost, you need a completed contract, and you need to have one that covers all the issues that you have. For an example, the first thing is any person who's going to deal with this contract must have background, education, experience. So let's just start with the people that judge it. A mediator must have background, education, experience in the home inspection industry. So therefore, let's do it differently. You must control the narrative. So here we go. The first thing is I have it written in my mediation clause, requirements that are deemed draconian or basically harmful. Not harmful, but strict. In other words, anybody can say, well, I know the construction industry, so therefore I know CREIA. I know that CREIA standards of practice. The answer is they don't. That's the whole point.
Exactly.
So I don't demand who they be. I only demand that the individuals chosen from must have the background, education, experience. So when, for an example, they send out a list of 5 or 6 names of individuals, I contact them and say, basically go into the CREIA standards of practice and do they know it? Well, I don't even go that far. I go and look at their resumes, whether it's JAMS, ADR, whatever it is. And if they don't list that they have background experience in the home inspection industry and the standards of practice of CREIA, they can't even be on my list.
Right.
So I eliminate all those ahead of time. And I'll give you an example. I once tried in the front page of the Los Angeles Times, there was an article about the vexatious litigant lawyer who had sued all these different people to get money and had made a fortune on it. And this time he was paying $168,000 to a law firm because they got him for attorney fees. It was my law firm. We got the vexatious litigant lawyer, and the other individual involved in that case was a guy named Rick Gore, who represents realtors. Bottom line of it is they talked about all these atrocities that this guy had been doing, intimidation, the whole works. In this particular article, it talked about him being a vexatious litigant lawyer. They're all out there. A lot of them.
Explain vexatious.
That means you purposely file lawsuits that you have reason to believe are invalid and shouldn't be filed, but you do it in order to get nuisance value because the insurance companies roll over. They don't want to pay the litigation costs of going through it, which is the biggest problem in our industry right now. The insurance companies are giving away money.
Yep.
So let's now come back to where we are. I have it limited in mind that says that they must have background education experience or they can't even get on the list. So when the list is sent out and I go through them, I write back to ADR or JAMS or something like that, and I'll say, in order to get on the list, according to this contract, they must have background education experience. I've read their resume. They don't mention CREIA or the home inspection industry at all. You need to give us 5 more that have that. And if you don't have them, we'll go to the next one.
Right.
Now, there's a rumor. There's just a rumor now.
Just a rumor.
Just a rumor that certain people do provide the standards of practice to certain mediators in advance. And there's a rumor that they put in saying they have read the standards of practice on their resume. And golly, I think that qualifies them to be on the list. And I'll give you another example where I tried an arbitration case. And this happened to be a case for La Rocca in which we won, but it was a major case. And we had an arbitrator. The arbitrator found for me, which I knew he'd do. And we then went back for attorney fees of $300,000, and we eventually got some money. The key to all of this was he then became a mediator, and he was assigned to one of my cases. So we're now sitting around the table, and we have plaintiff's lawyer and the client, and I'm sitting across the table with my client, the home inspector, and the mediator turns to the plaintiff's lawyer and says, well, explain your case. And he goes through his case, and his client says a few words and so forth. And then he looks at me, and he goes, wait a minute, Mr. Pyfrom. And he asked the first 10 questions that I would have asked. I'd had so many mediations with him. He already knew the first 10 questions. And by the time he finished the 10 questions, he said, look, you don't have a case. I never got to say a word at the mediation, not one. And eventually what occurred was they gave us a dismissal for a waiver of costs.
So he told the plaintiffs they had no case.
Right. Basically, I mean, yeah.
Because he understood
He
standards.
knew the whole standards.
Yep.
He asked the questions when I was there.
Got it.
Okay. And then he stopped me from saying a word and said, Mr. Pyfrom, you and your client step out. And then he told him, he says, you don't have a case. You're going to lose. And he's going to come after you for attorney fees. And he got $300,000 from this one on another case I was on. He said, you don't want to do this. Just die.
Just run.
Yeah, right. So then he got up. He left them there. He walked in and said, Greg, I've got you a dismissal for waiver of costs. You're going to take it. And I said, I want the attorney fees. He says, no, Greg, you're going to take it. I said, oh, I'd take it. Sure. The clients just wanted out.
Yeah.
Okay. But you have to set the stage for the right players.
The narrative.
So you've got it going. You've got the narrative. You've got it set up. Now, I have gotten more cases dismissed on an oddity. And I don't know why. One day I came up with it. And that is, a lawyer has to give notice to the other side as it relates to a demand for mediation. That is case law. Okay? Or you lose your attorney fees. Now, in every real estate transaction, it has that. It's generally paragraph 22 or 23 found on page 8 of the standard residential purchase agreement, RPA. And generally speaking, on the next page, page 9, depending upon which form you get, is either paragraph 25 or 28. That's the attorney fees clause. Just happen to know that. So, all right, now we come to the next side of it. The next side of it is how do you get to a point that you can get the cases dismissed day one? Well, this is what you do.
Wouldn't that be lovely?
I get it done all the time, and this is how it is. In my contract, it says that you must give notification of a demand for mediation, not just a demand, but it must be sent return receipt request before you file your complaint. Why? Because if it's not return receipt request, it's amazing how they have a copy of that notification. You just got lost in the mail if you don't have return receipt request.
Yeah.
So therefore, they call me up when I say, are you giving me a dismissal? He said, why? I said, because you didn't do a mediation. He said, I'm sure I've got it. And he said, remember, return receipt request. Do you have the document? He said, let me take a look. And he calls back and said, would you accept a dismissal for waiver of costs? Day one, right out of the bag. And the answer is yes, because the insurance company's going to say yes, and they've got no damages. But that's why it's in there. But CREIA took it out of theirs.
Right. Well, this, let me, am I interrupting you? You got something else to say? Okay.
No.
All right. So basically, this brings up, remember about 4 or 5 years ago, I was talking to you and I said, hey, you know what? I got this bogus claim about a mold issue on a house that I reported, like 14 different areas of the house. I had moisture damage, recommended further evaluation of all the problem areas. So long story short, several months later, I get this demand for $5,000 and they try to take me to small claims court. And I'm like looking at my contract going, I'm pretty sure there's a mandatory arbitration.
In my contracts, there
Arbitration.
is.
Yeah,
In my
right.
contract,
It's right here.
No. In my contracts, it says you have, by signing this contract, you agree that you cannot go to small claims except for the price of the inspection agreement that's done by the contractor. Inspector, I'm sorry.
So basically, I had to get my insurance company involved. And then they found me a lawyer here in LA who, to me, was useless. And I remember telling you about this. You might have forgot about it. So all of a sudden, I'm like waiting for things to start happening. Like, I got everything together. I got my report, my contract. There's no issue whatsoever with a signed contract being, invalid or anything like that. That was all a no-brainer. And then I contact the lawyer's office, and I get this assistant or a legal aid. And she's like, okay, we're going to help you get ready for small claims. So I'm like, what? You're going to do what? Well, this small claims complaint, we're going to get you ready for it. I'm like, did you guys not even read the inspection contract I sent over? It's got it right there. It's a mandatory arbitration here. So why are you prepping me for small claims court? Shouldn't you be sending a letter back to the plaintiff saying, hey, look, you just breached your contract by trying to take us to small claims court? Because it clearly says that's not what we agreed to. Amazingly enough, the next day, they send that letter after I asked them to send it. Went away. Just like that.
These people, look, insurance companies.
What I'm getting at is the lawyer never read that contract that was supposed to be representing me.
No. What happened here was the insurance adjuster that you paid money for didn't read it. Okay. The key to this is, think of it a different way. You are an orthopedic surgeon. In doing a knee transplant.
Do I get the money that goes with it?
You don't get the pain either. You're an orthopedic surgeon. You're replacing a knee, and it goes badly. Would you want a family law a family law lawyer representing you?
Absolutely not.
But that's what they're doing now. They have no respect, the insurance companies, for your standards of practice. I've been fighting this now for just under 30 years. That is the problem we have, not you,
right,
but all of the home inspectors, because they don't do what other professions do. And I'll give you an example. Dentists were in the same situation. They were getting hammered. So they hired an insurance agency that combined everybody together in one basket. And then they said, I have 300 of these policies, or 500, or whatever the number was. And they went out to all the professional insurance companies and said, if you want all these policies and the premiums, you have to bid for it. And you must have these specialists handling it who specialize in this profession. Their rates dropped 22% in 3 years.
Wow.
There was a company that I was dealing with that when I was brought in, and I won't mention their name, who was paying over $100,000 a year for insurance with 12 inspectors. Now they have far more, and they're paying just under $30,000 a year for the coverage because they went to a $25,000 self-insured deductible where their people came in, they handled it, and they took care of it. And the insurance company was notified as to settlements, but they could not control what was done in the case.
Got it.
We have another case that I filed a summary judgment on where they blew the statute of limitations by years. The insurance company is upset because of the amount of time and money I put into that case to get the information, to get the client off for nothing. And they're saying, I'm spending too much money. And they're going to get the money back. Look, they don't care. You are such a small grain of sand.
Minuscule,
on the beach.
yeah.
The key, though, is if you control the narrative from day one, they make nothing but money. Nothing but money.
Got it.